I was just introducing myself. As Taylor said, I'm Heather Tenney, and also joining us today is Bill Hudson. Here's some lovely photos of us and our little mini bios. You can go to the next slide. So, I'm sort of going to try and keep us on the sort of roadmap. So first we'll start off with that roadmap. So what we intend to cover today is, understanding what titling means, the consequences of titling, how to remove or correct a titling entry, and then also discuss some of the recent changes to this process as well as the appeals process. Next slide, please. So what is this problem? So basically, this comes up when a service member, and that can also include federal employees who may be assigned to a military installation or working on a military installation, veterans, when you're suspected of committing a crime, or accused of committing a crime, military law enforcement, will begin an investigation, or your command might start an investigation, and that can lead to being placed on a title block in an investigative report, and this is what is known as titling. And this mundane, routine procedure can have, frankly, a devastating impact to the person's career and the advancement of a person, not only in their military career, but also in their civilian life. So that's why we're going to talk about these issues. And as an example, how does this problem often come up? Well, say you've just recently applied for a position, and you're going through that interim period between the time you receive the tentative offer and the time that you get your final offer and your start date. And in that time frame, they're often doing a background investigation. Now, sometimes you're doing an actual security clearance application. Sometimes it's more like a suitability inquiry. So they're just reviewing, you do either a SF-85 or an OF-306, and you don't hear anything. But then all of a sudden, you get notice that your offer has been rescinded. And sometimes they give you a little bit of information about it. Other times it just says it's rescinded due to information in the background. And then you're left with a big question mark. Well, what has likely happened is you had a title in your record and you weren't aware that it existed. So some of the things that we're going to talk about today is, number one, trying to make sure you find out about those things, but also how to potentially correct those things when they may be wrong or inaccurate. Anything to add, Bill, before we get started?
No, I think it's a great point, Heather. I mean, the bottom line is that it is realizing that titling is not a judicial standard. It really is an administrative procedure used by the defense investigative agencies, and the long-lasting effect on an individual is pretty severe if, in fact, the titling is incorrect. And we're going to hopefully talk to you today about ways to remove or amend and what the issues are to help those service members and veterans who've in fact been titled, and then try to recover and see what we can do to help.
So Taylor, next slide, please. Now, Bill just mentioned a couple of these things, but, as we said, titling is the decision to place a name of a person in the subject block of either a CID or an NCIS or an Air Force Office of Special Investigations report. And obviously there's other types of law enforcement too, but those are kind of the main ones that will obviously there's the Coast Guard Investigative Service, but they've titled you by putting your name as a subject. But unlike a criminal conviction, which requires that you have proof beyond a reasonable doubt, to title someone only really requires that there's credible information that the person committed the criminal offense. It's a very low standard. It's not, as Bill just said a minute ago, this is not a judicial standard. It's not a disciplinary standard. It's an administrative procedure. Let's go to the next slide. And this sort of is a follow-on in terms of when we say it's not a judicial procedure, it isn't saying that the person has been arrested. It's not saying that the person has been charged necessarily with the crime or convicted of the crime. The primary purpose of titling is to ensure information in a report can be retrieved by law enforcement and for security purposes. So really, it is sometimes titling is also called indexing. It's a way for these different organizations and investigatory bodies to access information. And then once titled, a report of investigation, or ROI, is indexed in this thing called the Defense Central Index of Investigations, or DCII. And, as a result of being indexed, the DCII means that the titling can follow you around wherever you go. So when you're applying for jobs, especially federal jobs, when you're getting a security clearance, when you're going through a background investigation, and even in kind of non-federal and military contexts as well. And that's part of the problem of titling. Even though titling is this operational function, it doesn't always appear that way to people in, maybe purely civilianized environments. Like, when somebody looks at your background check, titling often looks like you've been arrested, even though that's not what the standard is. Next slide, please.
And HT, I will tell you that as Heather mentioned, that we've got 27 agencies have access to this DCII. And that's the issue. It gets about 35 or 40,000 hits a day. And once you're in the DCII, it's available for 40 years. There's the longevity of this one here. And so once titled, it appears on FBI background checks, or it appears that a service member was arrested, convicted, or even charged with something that maybe it did not take place. Again, this is an administrative procedure made for these investigative agencies to put somebody in this report of investigation, but it remains forever in the DCII unless removed. And the issue, as we've bolded in the slide here, once titled, removal not only becomes difficult, but many service members and veterans thereafter never know that titling action was taken against them.
Yeah. And what Bill's talking about is, like, it's not that this DCII thing is just their own little indexing where only the Department of Defense is then using this to track these records. The problem is, once this record gets created, it then sort of has legs of its own. The FBI winds up going into basically your what looks like your criminal record. And unfortunately, many of the people who wind up having access to that don't understand the distinction between the legal standard behind what is necessary to title someone versus what would be the standard for an arrest or a conviction. So that's where the real problem comes in is, number one, people don't really know about it, but even if you do know about it and you thought, oh, well, I know I got, I was investigated for that thing, but I never got convicted. That doesn't mean, though, that your record then reflects that there's nothing there. It reflects that there's something is there, but it isn't necessarily understood what that means. And that's some of the things that, we're trying to work on here to make sure that, number one, people have knowledge, but then number two, if there are things that could be removed or corrected or made more accurate, that people take the steps to do so. Next slide, please.
And just to follow up, that the issue also is you're in a database, and then when you go defend yourself, it's your word against the database. And so whoever is looking at the database, while you may orally be articulate in defending yourself, if it's codified in the database, it's hard to overcome. And this is the implications of the titling.
So, and as we've been talking about, this idea of implications, the consequences. So, this is not just, again, something that, okay, the military does this, but then when I'm out, everything's fine, or when I'm a federal employee, this is just something when I'm at this installation. that has an issue. No, the thing is that this becomes part of your record so that it can have effects in civilian employment decisions, military assignment decisions. It can have issues in whether or not you can even access military installations, obviously security clearance determinations, weapons permit decisions. It can even influence whether you can become a foster parent or adopt. These things have very long reach, so it's very important that you make yourself aware of what could possibly be in your record, and then obviously if inaccurate or needs to seek out some sort of correction or removal, that you take those steps to do so, because it's not as simple as just like, okay, well that happened years ago, I didn't get convicted, so everything's fine. And as an example of this, I had a client once who, he did have some incident. He was aware that something happened when he was in the military. He had been investigated. It started out as a very serious accusation. He, though, wound up going through the investigation. Most of it ultimately was unsubstantiated against him, but he did wind up receiving an Article 15, so non-judicial punishment, for underage drinking. So, he goes on, lives his life, is discharged honorably from, the service branch. He then goes and uses his GI Bill, gets a degree in criminal justice, and he is now applying to become a sheriff's deputy. And he's talking, he's interviewing, they are telling him how great he is, but at one point they're like, listen, man, we can't take you though, because, you've got burglary and larceny and conspiracy in your background check. And of course, this guy's like, what? He's like, yeah, you got, and in fact, they're like, you got an Article 15 for those things. He's like, no, I did not. So he reached out to us, and we wound up getting his records, and he had been titled for all those things. But the bigger problem for him was not just the titling. The titling at the time was actually accurate because he had been investigated for those things. However, the entry that then existed in his record was that he had received an Article 15 for all those things as well. And this was an error. What had happened is when CID, this was an Army case, when they had closed out the case, yes, the person had received an Article 15, but they received an Article 15 for underage drinking. However, they just cleared the entire matter, saying it was disposed of with NJP, and therefore when it got entered into his record, it looked like he received non-judicial punishment, an Article 15, for all of those offenses. Now, that sheriff's department could not care less if all he had received was an Article 15 for underage drinking, but as a law enforcement entity, they were not willing to accept somebody that they thought that there had been a determination, by, this non-judicial process where he had received, an Article 15 for larceny and conspiracy. So he was now potentially going to be out of that job. Now, luckily, we wound up getting all the records. We made an application, and we had his record corrected, so it no longer included the disposition of, a Article 15, a non-judicial punishment for those other offenses. So that actually wound up working out for him. He wound up getting a job in law enforcement, and he went off and did great things. But that's the type of consequence that we're talking about. It's not just an issue of does the title exist, but also even if the title is correct in the sense that there was an investigation, is the actual reporting accurate as well?
Yeah, and I'll echo that. I mean, I look at it as the dangling Chad, that you could have charges out there, but not only the charges are not addressed. And so you have this assault or alcohol or drug use, and it just hangs out there with no correct disposition. And so you have the situation where an individual is trying to defend him or herself in a situation, but all the other receiver receiving is this database that reflects only half of what happened. And that's the whole impact of titling and what we're trying to do to help those that are going through this problem.
So let's talk about that. How do we correct remove these things. Next slide, please. So, ultimately, from its most basic level, when you're trying to correct these things, you're going to be sending appropriate documents and evidence to correct, expunge, remove personal identifying information from the law enforcement or criminal investigative report, the index item or the entry, or any other record maintained in connection with that report or index. Now, as I was saying a couple minutes ago when I was describing the story about the person who had those titles for larceny and burglary, at the time we were helping him, the law was actually different. Now, for him, we were focusing more on just trying to correct it because at the time, this was prior to 2021, really the only ways you could get titles actually removed was if you could show basically that it wasn't you. It was like your evil twin, or they had made an error in, it was not your social security number, or that you really could show that at the time of the titling, there was no evidence, not at the time that the matter was resolved, but at the time of the decision to title, which is often at the very beginning of an investigation, when the accusation is made, before any of the, contrary information is known. So that's a very, very hard, burden to overcome, because as long as somebody made an allegation against you, then that's some evidence to support it. Well, that obviously did not seem fair, and that was the law for a very long time. But then in 2021, actually in 2020, but it became the act for 2021, the National Defense Authorization Act that year made specific amendments. And it now allows certain information that was not previously taken into consideration to now be considered in these requests. Next slide, please. So what you're then doing is you start off this process when you're seeking to remove, correct, amend, or correct factual inaccuracies. You're going to make a request to whatever the DOD investigating agency at issue is for the relief with supporting documents. Next slide. Now, like we were saying before, sometimes, you get some amount of information or you remember something that happened, but obviously the first step in any of this, if you're going to be seeking out correction or if you just want to make sure, is you have to request your records. So you want to make sure that you request your FBI identity history, and that you can do right on a website. You can Google FBI identity history, and it takes you to a site. You actually have to get your fingerprints done, though, to do it. And then you put it in, and you ultimately get that request back. Also, too, though, you don't want to just rely on that. That will give you the entry itself, but it won't give you potentially some of the supporting documents that then created that entry. So then you also want to make a request to, whether it was, CID, NCIS, OSI, CGIS, any of these organizations that may have been the ones who created the record, who you would have had the encounter with. Now, sometimes you wind up getting the FBI identity history first, because if you really did have very little knowledge or no knowledge, you then know now where to then look for the additional information. For other people who may have remembered, oh yeah, I got called in by CID at some point, I'm gonna request that thing, but you should always request your FBI identity history if you can, because you don't know the nature and scope of what's actually been reported.
And just a note too, that title is a word. For example, the Office of Special Investigators of the Air Force doesn't use the word title. They used arrest.
Yeah, so they actually use the term arrest, even though, again, it's the same issue in terms of it's not the same standard that everybody, maybe on the civilian side is more used to with arrest, where you have to have probable cause. Probable cause is not the standard for titling. It is a lesser standard. It's basically like kind of reasonable suspicion standard. So next slide, please.
So generally, we list how the agencies will grant correction, expungement or removal. Expungement is the most drastic piece of it. Removal, again, is taking the name off or even amending it. We want to make sure that we can help someone out. So they look at three of these prongs here, whether there is insufficient evidence to prove the crime ever occurred, if there's insufficient evidence to prove the service member or the veteran in question was responsible, and then there may be any other circumstances as prescribed by the Secretary of Defense. So these are these three prongs as to generally the agencies may grant correction, expungement, or removal. Again,
So that last one, that's real vague, as you can see. So that one takes into kind of consideration maybe unique or unusual circumstances, or it could even be things that are maybe more like right now, some people are seeking to have titles involving like drugs removed because there's obviously a change in many civilian states' laws regarding that. So that could be an argument there. Now, will it be a very good argument? Probably not, because the standard obviously for the federal government and the military are different, but obviously as more opinions and circumstances and minds change on issues, that can be a method by trying to attack more what we call like the equities, the injustices, that maybe there was some evidence, but based on sort of the spirit of all of these, it's really not equitable to have that entry in there anymore, because it really doesn't ultimately amount to something that's fair and just and doesn't really reflect what actually happened. Next slide.
Heather had mentioned how the Congress has gotten involved, and having worked in congressional liaison for many years, as you can see, the 2021 National Defense Authorization Act really helped out individuals who were going through this problem with title. And so they looked at what are several considerations. Again, before that, it was difficult. And so they looked at the extent of corroborating evidence against the individual with respect to the offense to see whether, in fact, that the titling should be removed. Whether adverse disciplinary or other actions were initiated against the individual. And I highlight in bold, that's a huge step there. I mean, if somebody was titled, but the unit took no dispositive action against the individual, that's grounds to say, well, perhaps remove or correct or amend what's on there. And then finally, the nature and outcome of the action taken against the individual. If something was taken, but for example, someone was given non-judicial punishment, captain's mast, Article 15, but as a result, though, it was locally filed, or in fact, there was an initiation of adverse elimination. They looked at all those factors to determine whether, in fact, the issue happened, but it wasn't that serious enough with which the unit would then determine that this person is no longer fit for the military. The unit determined that while the incident occurred, we're still keeping this individual on active duty or in the reserves. And so these are highlights there. So look at that number 2 change.
Yeah, and as Bill was saying, when he was talking about the highlighted one there, that is a major change. Before this NDAA change in 2021, it didn't matter if you actually had faced no action as a result of this title, that the commander took no action, no prosecutor elected to prosecute, that they even unsubstantiated it at the law enforcement entity. That didn't matter. Now, obviously, it's a factor in consideration. So that's a huge step forward, because before this time, we used to tell people when they would contact us about trying to get titles removed, well, maybe we can get some of the factual inaccuracies corrected, but the idea of removing it is, a near impossibility unless, like we said, it's the evil twin scenario where it really legitimately just was not you, and they made an actual practical, typing error when they were entering this into the system. So much, much different, much more now favorable circumstances to now seek relief. And part of this, a lot of, most of the changes that happen when Congress takes action is usually related to a specific thing. So a lot of the issues related to titling happened as a result of, and some of you may be familiar with it, they called it ARAP or GRAP, where in the Army Reserves and the National Guard, there were these recruiting incentives. Well, as a result of that, there was this belief that there was this huge amount of fraud that was going on, where people were putting in, saying that they had, recruited this individual and putting in, people would get like $2,000 for these different like recruitment contacts. And they set up a whole actual special like unit of CID to actually investigate all this, what they thought was fraud. But there was a lot of, frankly, fraud in that process when they were investigating. They titled thousands of people for these things, and people lost jobs, got kicked out of the military, lost security clearances because they were titled for fraud, and then ultimately even action taken against them for fraud based on this GRAP and AAR rap stuff. Well, they then obviously started looking back at what happened through this process and realized a lot of that investigation was not based on legally competent evidence, that in fact a lot of people did in fact do exactly what they were supposed to do in accordance with the rules of that program. So in order to try and make it right, they recognize, well, one thing obviously we can do is to try and correct the record. But obviously the titling stuff still existed. So out of that came a lot of these changes where other people who have nothing to do with, GRAP or AER rap can now seek to get correction of their records, for, what are ultimately inaccuracies, insufficient evidence, and that's obviously a good thing. Next slide.
But as we discuss here, this is not an easy process. And the burden is on the applicant. The burden is on those individuals who are titled to be able to seek removal, expungement, or correction of the titling. So if a request is denied from an agency to remove, that agency being CID, NCIS, OSI, to amend or correct the titling entry, then the service member or veteran can request relief, but you've got to go to your respective branch boards for corrections of military or naval records. I just had a case the other day where an individual tested positive, command didn't do anything, they think there was an issue, he was still titled. The CID still determined that they weren't going to either remove or amend the titling action, and so we're helping the individual out, go to their respective board of corrections or of military records and trying to help them correct that titling and remove or correct what happened in there. So again, I want to emphasize the burden is on the applicant. You have to take the affirmative ability and the affirmative movement to be able to correct the issue there.
Yeah. And again, like as we're talking about it, like we're talking in kind of a general sense, but what you're doing here is, as we said, you're getting your records. So you're developing the information so you know what it is, but also you're getting your records, from the actual, service branch, law enforcement, because you're trying to show what is actually in there that you may be able to refute. But that doesn't mean you just put in a request and ask for it. You're having to then support what is the information that shows that there was an insufficiency in the evidence? Where is the evidence that shows that there was no action taken? Now, some of that's going to be obviously in your record, because if you didn't receive, non-judicial punishment, a letter of reprimand or a GOMAR, or you didn't receive, you obviously didn't go to court martial, that's there, but that's not just it. You have to ultimately address these issues. And that's why, again, it's more complicated than just, I'm putting in this application, fix my record because you're wrong. We bear the burden. We have to ultimately lay out the different issues, the different evidence to show, why either it's an actual error, why there's insufficiencies, or like we were talking about in the last component, kind of the injustice aspect. But again, not just an injustice to you generally, but really such an injustice that the secretary concerned should take action to correct it. Next slide, please.
We talked about recent changes and issues in last year's fiscal year 2023 National Defense Authorization Act. The requirement was, it required the Department of Defense to notify those service members who were leaving service if in fact they were titled for any action, and if in fact they were titled, what was the appropriate relief and how they could, again, the burden is on them, but they would affirmatively say, here's how you can apply to get the titling removed, amended, or corrected to the respective investigative agency or the respective Board of Corrections. Again, no burden on the DOD. All of this, it was a requirement that they let the individuals know if they've been titled. I will tell you that even in this year's National Defense Authorization Act, although never passed, these statutes never made it into the bill itself. You can see how where this is moving, where in fact it was proposed that if in fact that if somebody was found not guilty at trial or at military trial, that could have been removed or amended automatically, or then they determined that the person was not responsible. That was the affirmative responsibility of the Defense Department to remove. Or in fact, if an offense was addressed through non-judicial punishment and involuntary separation was not recommended, again, the proffer in the NDAA was to amend or remove. Those never made it into the NDAA, but you see where this is moving because it's caused so many service members and veterans some harm on this titling issue.
Mm-hmm. But again, obviously what it also shows though is, yes, maybe that's where the tides are going, where the winds are blowing, but right now that's not the standard. So again, the obligation is on the applicant to do these things. It's not a situation where the Department of Defense is going to go and scrub through records and make these corrections, on their own. And they're also not looking just purely like, okay, because you weren't convicted or given the non-judicial, but we are automatically taking those things away. It's just a consideration that is used. Now, again, better than it used to be, but still not perfect, still a far way to go. Next slide, please.
I guess if we had to make recommendations, it would be that encourage those in uniform and veterans to check their records. Remember that,
especially if you're in the process of applying for jobs, especially federal jobs, especially when they require background checks and security clearances. And really, any federal job is going to require some level of background check. You may not require a security clearance, but every job requires you being suitable, which is generally considered public trust, and they will do a background check. So make sure that you are informed. Just like you need to check your credit report, you need to make sure you know what's in your criminal background check. And don't go to commercial sites. Commercial background checks do not have the same information that the FBI has.
remember again, you not only bear the burden of checking your records, but affirmatively submitting the evidence to request removal, correction, or amending. And then finally, it is a complicated process. And because the evidence needed is you've got to be able to justify why the titling needs to be expunged, removed, or amended. And so we always advocate seeking competent legal counsel to assist in the preparation and submission of the request, either to the investigative agency or the respective Board of Corrections or military or naval records.
Now, the next slide is going to be like the question slide. So before though we get into sort of the general questions that maybe have been coming in, we got some questions beforehand. One that I thought was particularly useful, we kind of addressed a little bit already. Somebody asked, and I won't reveal exact details because we don't want to share any personal information, but this person had been applying for a position, had received a tentative offer, and then that offer was rescinded. And they're asking, well, there was no appeals process. What can they do? Can we help? Well, unfortunately, when it comes to this offer that just got rescinded, no. That's part of the problem that we're trying to address here, is that in that scenario, you don't have appeal options. What you need to do is take steps ahead of time to try and address it. Now, sometimes you can't take the steps to actually correct the record beforehand. But if you are applying and you know that there is something in your background that you've been titled for, or even forget titling, just something in your background, it is usually a good idea to reach out to somebody like us to talk about how do you fill out things like the OF 306. How do you fill out the SF-86? How do you fill out the SF-85P, the security clearance, the public trust, the, general information for, background for federal employment? Because you're not, when you answer those questions, it's not like you're answering in a vacuum. They are asking you specific questions. However, the answers that you may give, if you're just answering like yes or no, that doesn't always help you, because you can be being honest, but what you also want to do is you want to try and what I like to call front load mitigation. So if you know that you have to disclose that, yes, I had an issue when I was in the military. Yes, I got titled for this, or forget even the subject we're talking about right now. You just know that, hey, I've got some bad debt. You want to make sure that you not just share that part of the information, but the positives, what you've done to try and resolve it, what you've done, to correct it, what you've done to potentially show that it's not actually accurate, and also, what you will continue to do that therefore shows that you're a trustworthy, reliable person who can safeguard information and who will be, an asset and can promote the efficiency and integrity of the federal government. Those are the standards for a security clearance and suitability. So it's important that you don't just go in flat-footed and say, okay, I disclosed everything. I've done my obligation. Sure, you won't necessarily get in trouble for lack of candor, but you're also not putting yourself in the position to be successful, so that if they do see something when they look at your background and you disclosed it, but you also told them, you shaped the narrative, you told them about that, and you told it from your perspective, and you told them about the favorable things that mean that stuff doesn't matter. Look, this person's great. They've remedied that. That's not going to be an issue going forward. So to answer that question for that guy, unfortunately, there's nothing you can do to get the offer back, but what you can do is put yourself in a better position going forward to get and keep those offers, and then get into the process where you're now going through the full adjudication process, not just getting shut down before you start the job.
I think we always say you control the narrative before being confronted by the facts. And HT has given some great examples there. You want to control the narrative and in your best narrative out there. And again, before being confronted by the facts and being on the defensive. So good example.
Now, some of the questions that I see that we've received, one is probably a little too general. It's just about like, I'm titled by a specific agency. How do I correct it? Well, that's what we've been talking about. There's probably specific things about that title and about the information that you may benefit from, reaching back out and maybe having an actual consultation with one of us so we can talk about the way ahead and even potentially help you do that. But I can't really answer how do you correct it, because I don't know what the title is for. I don't know what the evidence is, but that's ultimately the process we've talked about here. But in terms of the actual kind of boots on ground, how do you get it done? That's going to require a lot more information and something we can't really discuss in the context of a webinar, because, people don't need to know your business, right? I'm not sure that I can answer this question. If you haven't seen it, Bill, I'll read it out, because it doesn't have any personal information. I'm not sure I really understand it though. Does the change in rules to make non-evidence corrections easier apply to all titling or only ones related to that recruitment program? Well, in terms of titling, the rules don't apply just to AAR wrap or GRAP. These are rules that have changed in general for titling, but remember, they're not non-evidence corrections. I mean, ultimately, you are trying to correct something about the record. Now, sometimes it's the actual idea of being titled and your name entirely. Sometimes it's that what they put in the title, like say they said that example I gave, they said that person received an Article 15 for things that they did not receive an Article 15 for. That wasn't a change to actually getting the title removed in its entirety, but it was trying to change what we would call the disposition of that charge or that title, But no, it does apply to, any type of titling. It's not just, AR, wrap, or GRAP. do we have any other questions? Make sure you type them in and we can answer them.
It was.
No, it was, and the person just apologized. It was not poorly phrased. I think I misunderstood it when I read it. It was perfectly fine.
Great. Hey, I think
any thoughts that you have, Bill?
No, I just, I haven't seen it on active duty for 27 years and then seeing it in the firm. Again, I want to caution and I want to urge those individuals, while you're in service, you have a little more leverage that you can at least contact the agency where you're in there to be able to say, what is this and what is this not? And so I encourage you, even though the Defense Department has an affirmative obligation to let those members know before they're discharge, ETS, and their military service obligation to see what's on their records. But I encourage those in uniform, but I strongly encourage those veterans. You don't want to be surprised. And obviously, I think this is a good primer with which to see what's out there. And again, you always want to control the narrative before being confronted by the facts. And I think that as you're seeing that more and more, even Congress realizes that this is an issue. And albeit I respect the defense agency's need to use this administrative procedure, I think realizing now that administrative procedure has hurt service members and veterans over the years, and there are ways around it, but you have to act affirmatively. And again, we're here to help if in fact that issue comes up. That's all I've got, HT.
In terms of somebody just asked about timing, again, anything involving the government is not fast. So typically when you're making your original request to the governing law enforcement organization, that can take upwards of 6 months plus for them to sometimes come back with a response and a decision. If it has to go further than that, if you have to go all the way to the Board of Corrections, depending on the Board of Corrections that you have to go to, if you have to go to the Army's board, it could take upwards of 2 years to get a response back. If you're going to the Air Force's board, that also could take upwards of 2 years. The Navy's usually a little bit under, but it's based on sort of, remember, these boards of correction don't just hear this issue. They hear all different types of issues of correction, and they get many, many thousands of applications per year, and they like to tell everybody how many applications they get per year to justify how long it takes, but they are very slow. So it's something that, it's, a good idea to look into and take the corrective steps sooner rather than later, because it's not something that's going to happen overnight. Now, somebody asked with regards to a what they call SILT, which is a separation in lieu of trial. Is that something that would likely appear up? Yes, because, ultimately you were likely titled for the underlying, offense when you were originally being investigated for it. And then it actually probably has a disposition that says you took administrative separation in lieu of being tried. So that's almost like, an admission. So that actually even may be difficult to overcome, because there's a presumption that it's almost like you agreed, you took a plea bargain to get it. But obviously every circumstance is different, and there might be evidence to support how that was unjustified and there wasn't sufficient evidence. But that would be something that, would definitely require, review of the record and, doing some analysis before there could be ever any determination about likelihoods of success or anything like that.
Well, listen, thank you all very much for hearing this presentation. I hope it was beneficial to you all. And I think that it's something that you all need to look at. I think it's something that there's a way ahead. And again, as I'll defer to my fellow partner there, Heather, but it's something that this firm can help. If you any issues, let know that this firm is ready to stand by to help on anything you would request. Heather?
And Taylor's put up this slide. So if somebody, especially if you have maybe longer questions or more specific questions, here's the contact information. And obviously we do consultations, where we can talk about, your more individualized facts and even potentially represent you to seek out correction of these issues or correction of your record.
Thank you everyone for joining today's webinar, and thank you Heather and Bill for presenting. This presentation was recorded and a copy will be sent to all attendees early next week. I hope everyone has a good rest of their night.
Good night
Thank you.
all. Thank you so much for attending.